Good day, everyone. I am going to present to you the case of Chotimo Rodriguez Cho-Cham, Petitioner Appellee versus Republic of the Philippines, Oppositor Appellant. So for the facts of this case, Chotimo Rodriguez Cho-Cham, born in Cebu City of Chinese parents, filed this petition for naturalization before the Court of First Instance of Cebu, praying that he be granted Philippine citizenship. During the hearing, petitioner asked that he be allowed to present evidence to show that long before the filing of the petition, he had already possessed the status of Filipino citizen. Some of the evidences presented by Cho-Cham were the following. First, he voted in the elections in the Philippines. He took the oath of allegiance as citizen of the Philippines before the Court of First Instance of Cebu. He also joined the Cebu Command with the rank of second lieutenant. He finished first-year high school. While all his children are presently studying in the schools recognized by the government, he is presently a businessman. He has sincere desire to learn and embrace the customs, traditions, and ideals of the Filipino people, and he has never been convicted of any crime involving moral turpitude. Now, the lower court granted this request, and after the presentation of the evidence of Cho-Cham, they found the same to be sufficient to consider him a Filipino citizen and rendered accordingly a decision declaring him Filipino citizen without the need of complying with the requirements of RA number 530 relative to the 2-year suspension of the period prior to the effectivity of the decision. They have also relied apparently on the decision rendered in the case of Roa versus Collector of Customs, which holds that those born in the Philippines of alien parents are deemed Filipino citizens by virtue of the principle of jus soli. From this decision, the government has appealed on the ground that petitioner is disqualified to be naturalized because he does not possess good moral character or has not behaved in a proper and irreproachable manner during his stay in the Philippines, for he had an illicit relation with another woman and begot Sonia Chu as a result. So the issue of this case is whether or not the petitioner is qualified for the benefit of the naturalization law. The court ruled that yes, petitioner can be given the benefit of our naturalization law, considering, as his evidence shows, he possesses all the qualifications and none of the disqualifications prescribed in the law for the acquisition of Philippine citizenship. However, it must be noted that the petitioner cannot invoke the benefit of the Roa decision for the reason that it has already been expressly overruled in the case of Tan Chong versus Secretary of Labor. The common law principle or rule of jus soli obtaining in England and in the United States has never been extended to this jurisdiction. More so, in the case of Tan Chong versus Secretary of Labor, it has been stated there that the law in force at that time is that of Section 4 Philippine Bill of 1902 and Section 2 Jones Law of 1916, which provides that only those inhabitants of the Philippine Islands continuing to reside therein who were Spanish subjects on the 11th day of April 1899 and then resided in said islands and their children born subsequent thereto shall be deemed and held to be citizens of the Philippine Islands. Those who had been declared to be Filipino citizens or upon whom such citizenship had been conferred by the courts is because of the doctrine or principle of res adjudicata and not because of the application of jus soli doctrine. More so, the government has not presented any evidence that may serve as basis for his disqualification, except the testimony of Mauro Magsaysay, who declared on a supposed investigation conducted by an agent of his office, wherein one Sonia Chu gave sworn statement on alleged illicit relation had by petitioner with a woman. And such evidence has been considered as incompetent, not only because the supposed sworn statement was not presented as evidence, but also because Sonia Chu never appeared to testify in spite of the opportunity given to her by the court to do. Therefore, the claim of the government that petitioner is disqualified to be naturalized because he does not possess good moral character or has not behaved in a proper and irreproachable manner during his stay in the Philippines cannot be sustained. Wherefrom the decision appealed from is modified in the sense that the petitioner is granted Philippine citizenship but subject to the requirements of RA number 530.